Today we will discuss the important MCQ on Indian Penal Code 1860. This is a very important topic, that is the offences affecting the human body and offences affecting life. So this is the part 1 of my video. We will discuss the MCQ with the objective questions, with the options and explanation with the answers. So we will begin with the first question. Offences against human body are provided under which of the following chapters of IPC? So options are A. Chapter 11, B. Chapter 12, C. Chapter 14, D. Chapter 16. The answer D is Chapter 16. So Chapter 16 deals with the offences affecting the human body from section 299 to section 377. And this was asked in the Chhattisgarh preliminary examination of 2014. The next question is, Justice Melville decision in R versus Govinda is a leading authority on law relating to A. Objective liability for murder, B. Murder under grave and sudden provocation, C. Murder in the course of sudden fight, D. Distinction between culpable homicide and murder. So you have to remember the justice name and the case name. So the correct answer is option D, that is the distinction between the culpable homicide and murder. And the next question is, which of the following pairs of section of Indian Penal Code pertains to culpable homicide and murder? The options are A. 34 and 149, B. 323 and 325, C. 299 and 300, D. None of the above. So the correct answer is option C, that is 299 and 300, and this was also asked in the Chhattisgarh in 2017 examination. So section 299 and section 300 of IPC defines culpable homicide and murder. And the next question is, for what Govinda, the accused in the famous case of R versus Govinda 1876 Bombay 342 was punished? The options are A. Culpable homicide, B. Grievous hurt, C. Murder, D. He was acquitted. So this is a famous case, और आप लोग जब भी IPC पढ़ते हैं तो ये केस हमेशा पढ़ा जाता है, and it is very important case. So all the facts relating covering all these MCQ regarding these case and upcoming जो भी questions में जो भी cases वगैरह आएंगे, आप लोग वो please अलग से उसको note down कर लीजिएगा and उसको एक सीक्वेंस वाइज भी बना लीजिएगा, क्योंकि मेरे जो ऑब्जेक्टिव क्वेश्चंस है वो टॉपिक से रिलेटेड हैं एंड सीरियल वाइज रहेंगे. तो जस्ट रिमेंबर दीज थिंग्स विच यू हैव टू नोट इट डाउन, एंड द करेक्ट आंसर फॉर दिस क्वेश्चन इज option A, that is culpable homicide. So yes, in this case the accused was convicted for the culpable homicide not amounting to murder. तो ये क्वेश्चन पूछा गया था उत्तराखंड CJ in 2018, and in the previous question I have also asked the distinction between the culpable homicide and murder, where R versus Govinda is the leading case on this topic. The next question is, culpable homicide is defined in section of IPC, that which section of IPC defines culpable homicide? And this was asked in the APO CBI examination, and this is also important, though already it is a direct question, but yet people do get confused. So I will give the sections, that is the option A is section 299, B is section 300, C is section 301, D is section 302. The correct answer is option A, that is section 299. So like the IPC, where it defines that section 299 of IPC, whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury is likely to cause death, or with the knowledge that he is likely by such act to cause death commits the offence of culpable homicide. So I have already given in my explanation that under section 299 whatever it says. The next question is, whoever caused death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death commits the offence of. This is the straightforward question. I have already discussed with this question, but you have to remember that question may be asked like this in the examination. So you have to remember the definition. I know many of you have got the right answer. So the options are A. Culpable homicide, B. Murder, C. Attempt to murder, D. None of these. The correct answer is option A, that is culpable homicide, and this was asked in the Gujarat preliminary examination in November 2019. So this आप लोग देख रहे हैं कि ये various states के questions हैं and topic wise. The next question is, culpable homicide has been defined under A. Section 299 of IPC, B. under Section 300 of IPC, C. under Section 302 of IPC, D. under Section 304 of IPC. So the correct answer is option number A, that is Section 299 of IPC. This is a repetitive question because this has been asked in many states like in Gujarat, in Assam, in Chandigarh and Chhattisgarh. So that is why this has been repeated. And the next question is, what does culpable signify? So here you see the word culpable has been asked. So what does culpable signifies? Let's see the options. Involving a breach of legal duty, B. blameworthy, C. socially unconscionable, D. both A and B. So the correct answer is option D, that is both A and B. So culpable signifies involving a breach of legal duty and blameworthy. So you must notice this question. This has been asked in the Chandigarh ADA examination 2015. Okay, so next question is, homicide is the A. killing of animals, B. killing of human beings, C. killing of birds, D. all of the above. So the correct answer is, look, this in the starting only I have told about this chapter which is concerned with the killing of, like attempting to kill, it's all about life and of human beings. So you can eliminate option A and C, and obviously D also. The correct answer will be answer B. So you can use this eliminating the options in your examination, एंड तब आप लोगों को काफ़ी समझ में आ जाएगा कि हाँ ये शायद नहीं हो सकता है, ये एक ऑप्शन बच रहा है. सो दिस मे हेल्प यू इन गेटिंग द राइट आंसर. Yes, the option B, which says that homicide is the killing of human beings. Although the term homicide is sometimes used like with the murder, homicide is broader in scope than murder, but murder is a formal of criminal homicide. So here it is killing of human being only. This was asked in the Tamil Nadu ADA examination 2014. The next question is, killing of human being by another human being is called option A. murder, B. culpable homicide, C. homicide, D. assassination. So here you may get confused between the options. Let me tell you the correct answer. It is C. homicide. Although I have discussed in the previous question, so you must have got the right answer, but still if it is asked directly, so people do get confused between the option B and C. So here killing of human being will be only homicide. I've told my explanation in the previous question, and this was asked in the Uttarakhand CSE examination in 2018. So look, the variant in the different form of questions and the options also. So it is clear now. The next question is about assertion and reason. So A, which says that homicide is the killing of a human being by another human being. Reason: homicide is always unlawful. So give the correct answer from the codes given below. Option A, both A and R are true, and R is the correct explanation of A. B, both A and R are true, but R is the correct explanation of A. C says A is true but R is false. D says A is false but R is true. So the correct answer is you must have seen relating to previous question, and उससे समझ में आ जाएगा कि ये इसका आंसर क्या होना चाहिए. But I will tell you the correct answer. The option is C, that is A is true and R is false. So homicide is always unlawful. No, it is not correct, because homicide is like killing of one human being by another, and homicide is not always criminal. For example, if I say that a lawful execution of a pursuant to the death penalty is a homicide, but it is not unlawful. जैसे जल्लाद लोग मारते हैं, लेकिन they are being under the exceptions, general exceptions, which is already I have covered in my previous video lectures, and if you want to see, you may go to my playlist and see the question relating to that. And my question and all these videos relating to MCQ will help you in revising the IPC and important topics. Plus, because they have been asked frequently in some or the other states, so it is very important and essential for all the aspirants who are preparing for any of the examination कि वो लोग ये वीडियोस अगर देख रहे हैं तो उनका पूरा रिवाइज हो जाएगा टॉपिक वाइज. एंड बिकॉज ये क्वेश्चंस हैं इम्पॉर्टेंट, आप लोगों को ये भी समझ में आएगा किस तरीके से किस जगह कैसे क्वेश्चंस पूछे जाते हैं. So this question has been asked in the UPPCSJ in 2013 also, and also in 2006. So this is important question, and you must see कि कैसे assertion और reasons के question पूछे जाते हैं. The next question is, which one of the following option is incorrect? The options are: all murders are culpable homicide but not vice versa. B, all culpable homicide are murder. C, an intention to kill is not always necessary to make out a case of murder. D, clause C of section 299 is required knowledge of the probability of death. So this was asked in the MP civil judge examination in 2018. So this is also an important question, and if you see what is the question is asking, that which one of the following option is incorrect. So here if I say that incorrect, you have to focus on the question that is incorrect. So the answer is B, that is all culpable homicide are murder. Yes, कि जैसे अगर हम देखते हैं यहाँ पर, लेट मी जस्ट एक्सप्लेन यू इन द वेन डायग्राम दैट ये अगर मर्डर है और ये कल्पेबल होमोसाइड है, तो कल्पेबल होमोसाइड यस इट इज़ इनसाइड द मर्डर. तो क्या होगा कि मर्डर जो है इट इज़ अ expanded form of culpable homicide. So all culpable homicide will be the murder. The next question is, a person who causes bodily injury to another person who is laboring under a disorder, disease or bodily infirmity and thereby accelerates the death of that person shall be deemed to have caused his death. The above rule is mentioned in option A, explanation 1 of section 299 of IPC. B, section explanation 2 of section 299 of IPC. C. Explanation 3 of section 299 of IPC. D. Explanation to exception 1 of section 300 of IPC. If you see, this question is no undoubtedly like thoda sa twisted form mein hai, yet directly, but you have to remember it. And this was asked in the ABO CBI examination in 2015. So just if you are preparing for APO or ADA examination of CBI and other examination, so you have to see the depth of the question which they are asking. Let me give you the correct answer. Option A is the correct option, which says the explanation 1 of section 299 of IPC. So here section if I talk about section 299 which I have already told deals with the culpable homicide. So once if you go to the bare act, you can read the explanation 1 of the 299 and you will get to know where this question is from. And this was, I have already told that in 2015 it was asked in the APO CBI examination. The next question is, under which of the following provisions of the Indian Penal Code 1860 causing death of child in the mother's womb not homicide? So again this is also an important question, and let me tell you the options of it. Explanation 1 of section 299, B. Explanation 3 of section 299, C. Explanation 1 of section 299, and D says explanation 5 of section 300. So the correct answer is option B, that is explanation 3 of section 299. Let me read you for this explanation because maybe आप लोग शायद बैराक read करें ना करें. So let me read it for you. Explanation 3 of section 299 of IPC states that causing death of a child in mother's womb is homicide to cause death of such a child if a child is a living child and any part of that child has been brought forth, even though the child may not have breath or may not have been completely born. So it will be covered as homicide, and explanation 3 of section 299 covers this part, and this was asked in the UP PCSJ in 2016 examination. So you have to see that the mindset of the UP, Uttarakhand, Chhattisgarh, Chandigarh and APO and other CBI examinations. So you have to look at the criteria that in what form they are asking the question. The next question is, causing of death of a child in mother's womb is option number A, culpable homicide, B, murder, C, not homicide, D, infanticide. So the correct answer is option C, that is not homicide. I have already told you that it is state that a child of his mother's womb is not homicide. The explanation I have given in the previous question, which is in the explanation 3 of the 299. This question makes more clarity than before. So the next question is, causing of death of a child in the mother's womb is not homicide as provided under option A is explanation 5 to section 300, B explanation 1 to section 299, C explanation 2 to section 299, D explanation 3 to section 299. I hope आप सबका ये आंसर सही होगा. So this is the revision form question, and the correct answer is obviously the option number D, that is explanation 3 to section 299. My above two questions are the questions related to this only, because it is asked in many of the state examination like Himachal Pradesh, Jharkhand, Haryana, UP. So this question is a favorite amongst all states. So like you all can revise this question, and I will move further with the next question is, The causing of death of child in the mother's womb is not homicide under A. Indian law only, B. English law only, C. Both English and Indian law, D. Neither in India law nor in English law. So this is the question asked in the Haryana examination 2011, and if we see the correct answer, it is option number C, that both English and Indian law. So here the explanation 3 of section 299, if I say that explanation 3 of 299, alright. So if we see the explanation 3 of section 299, which says that in respect of Indian law, the same is in the English law, which provides the that causing of death of child in the mother's womb is not a homicide. Fine. So the next question is J. A priest beats a boy for curing him from evil spirit. The boy dies. J is A. Not liable for any offence, B. Liable for culpable homicide, C. Entitled to defense of good faith, D. Liable for attempt to murder. So here if we see the options, आप लोगों को जो भी समझ आ रहा होगा प्लीज़ कमेंट बॉक्स में आप लिखिए ज़रूर इसको, and just see what is the right answer. The answer is option number B, that he is liable for culpable homicide, because if it is like covered under section 299 of IPC, where he is like causing death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or which the knowledge that he is likely by such act to cause death commits the offence of culpable homicide. So here the culpable homicide has been defined very clearly, and here as like he beats the boy. Fine, although he is curing from evil spirit, but he knows that if he beats, the consequences may come in adverse effect also. So this was asked in the UPPCSJ in 2003. So if you have to see the examples also, these are the examples mentioned under section 299 of IPC. I am covering the questions of examples also, assertion reasons also, plus the cases also, and so you have to see all the questions. The next question is Jed attempts to horsewhip A, not in such a manner as to cause grievous hurt to A. A draws out a pistol. Jed persists in the assaults. A, believing in good faith that he can by no other means prevent himself from being horsewhipped, shoots Jed dead. A is guilty of A, murder, B, grievous hurt, C, culpable homicide, D, none of the above. So this is the also example, and although my questions are relating to the topic, because this is covered, like all the questions here right now are covered under culpable homicide. So you all must have got the right answer, because the option C is the correct, that is culpable homicide. And later on when I will come under murder, so like in examination obviously the question will not be in the series form and it will come directly, तो कभी culpable homicide and murder का भी हो सकता है. So you have to see कि which question is of culpable homicide and which are of murder. तो आप लोग इसको डिस्टिंग्विश कर लेना, एंड ज़रूर इन जो भी मैं एग्जांपल्स को कोट डाउन करके बता रही हूँ इसमें, आप प्लीज़ उसको ध्यान में रखिए एंड उसको देखिएगा कि ये किस टॉपिक में फॉल कर रहा है. तो हियर इट इज़ अंडर कल्पेबल होमोसाइड, बिकॉज ए हियर like if you read the culpable homicide under section 299, you will get to know the reason behind it. And this was asked in the Punjab in 2013 and also in Tamil Nadu in 2014. So the next question is A shoots B with intention of killing, B dies in consequence. A commits A. Culpable homicide. B. Voluntary causing grievous hurt. C. Assault. D. Criminal use of force. So here the correct answer is option number A, that is culpable homicide, because A is shooting B with the intention of killing. So and in the consequence B dies. So now here it is the culpable homicide. The options is A. The next question is, X and Y are at quarrel. It develops into fight in which both suffer bodily injury. However, Y suffers more grievous hurt and dies after 3 days in hospital. X will be liable for A. Causing grievous hurt, B. Murder, C. Culpable homicide, D. No offence. So you all must write the correct answer to it, because yes, it is option number C, that is culpable homicide, and this was asked in the Uttarakhand CJ examination in 2018. So again I will move to next question. A lays stick and turf over a pit with the intention of causing death, or with the knowledge that death is likely to be thereby caused. Jet, believing the ground to be firm, treads on it, falls and is killed. A is guilty of A. Murder, B. Culpable homicide not amounting to murder, C. Voluntary causing grievous hurt, D. No offence as Jet fell in the pit by accident. So आप लोगों को क्या लगता है इसका आंसर क्या होना चाहिए? ऑप्शन नंबर बी, दैट इज कल्पेबल होमोसाइड नॉट अमाउंटिंग टू मर्डर. Fine. So this is the illustration A of section 299 of IPC. So if I like, I'll mention it is illustration A. Fine. The next question is, A knows Jet to be behind the bush, B does not know it. A induces B to fire at the bush knowing it is likely to cause Jet's death. Jet dies. A is guilty of A. abetment to murder, C. culpable homicide, C. attempt to murder, D. none of these. The correct answer is option number B, that is culpable homicide. This is also important example and illustration which is mentioned in section 299, and this is illustration. Again I will write illustration B. Fine. So illustration B of 299 covers this question, and it is culpable homicide, and this is asked in the MPCJ in 2011. This is important question, and this has been repeatedly asked in the MP and Delhi and also in the Maharashtra. So you all have to see this question again. The next question is, Y gives grave and sudden provocation to X. X on this provocation fires a pistol at Y, neither intending nor knowing himself to be likely to kill who is near him but out of sight. So X kills Z. X guilty of A. murder, B. culpable homicide, C. no offence as death of Z was caused by accident or misfortune, D. an offence punishable under section 304A of IPC for doing a rash or negligent act not amounting to culpable homicide. Let me tell you, this question has been asked in the Delhi Judiciary Preliminary Examination in 2019. Yes, it is an important question to be noted down, and the correct answer is option number B, that is culpable homicide. And this is also the illustration in section 299 of IPC. Fine. The next question is, A beats his wife, she fell down and became unconscious. Believing her to be dead and to save himself from being arrested from murder, A hanged her on the fan with rope. Post-mortem report disclosed her death from hanging. A is liable for A. Murder, B. Hurt, C. Culpable homicide, D. Grievous hurt. People do get confused in this question a lot between option A and option C, but here the correct answer is option number C, that is culpable homicide. So you have to remember this question, and you have to look into the significance of this question, because these questions are very confusing, and it gives confusion between the murder and culpable homicide. This was asked in the Haryana in 2015. So here A has committed the offence of culpable homicide. The next question is, P gives grave and sudden provocation to M. M fixes a pistol at P, neither intending nor knowing himself to be likely to kill Q, who is near him, but out of sight M kills Q. M has committed A. Murder, B. Culpable homicide, C. Neither a murder nor culpable homicide, D. All of these. So yes, the correct answer is obviously it will be B, but I will again say that these question and illustration, I have to remember that which falls under murder or culpable homicide, because these are very confusing, and in the examination all these questions will directly come and the options makes you confused. So it is the question based on the illustration B of exception 1 of section 300. So let me write to you all that it is illustration B, fine, of exception it is I've told that it is exception 1 of section 300, fine. So of 300 it is the exception. The next question is, it is within the knowledge of R that Q is hiding himself behind a curtain, but S is having no knowledge of it. R, intending to cause death of Q, induces S to fire at curtain. S fires accordingly, resulting into the death of Q. In this factual background, which statement of the following is correct? So you have to see the options carefully. R has not committed any offence. B. R has committed an offence of culpable homicide not amounting to murder. C. R has caused death by negligence. D. S may be guilty of no offence. So here what do you all understand? Please comment in the comment box and let me just see what question and you are getting the right answer of these questions. You will build a self confidence if you get the right answer, and if not, you will get to know that where the revision and we are lacking behind. So what you have to focus on it. It will give you the clarity. So the correct answer is option number D, that S may be guilty of no offence, because here S may be but R has committed the offence of culpable homicide, and because here the option has not been given that R has committed the offence of culpable homicide. So here the option D will come. Option B will not come, because option B says that offence of culpable homicide not amounting to murder, but the correct answer will be R has committed the offence of culpable homicide. So whether the appropriate option will be D, and this is also based in the illustration B of section 299. Fine. The next question is, look, these questions are very important to discuss, and this video will give you most appropriate way of revising your topic by seeing the the actual method of asking questions of different states, and the depth intentions behind their asking the questions. So I will move further with the next question, because questions are much, and I am explaining because this will help you in your revision. So the question is, this is a very easy question, and most of you all have got the right answer. Murder under IPC is defined under section A, section 301, B, section 302, C, section 299, D, section 300. So the correct answer is option number D, that is section 300. Yes, 300 defines the term murder. Question is, Jet strikes B. B is by this provocation excited to violent rage. A bystander intending to take advantage of B's rage and to cause him to kill Jet puts a knife into B's hand for that purpose. B kills Jet with the knife. What offence A is liable for? A. Murder. B. Culpable homicide not amounting to murder. C. Abetment for murder. D. None of the above. The correct answer is option number A, that is murder. So now here the options relating to murder will start, but you have to see whether they are like culpable homicide or murder, or culpable homicide not amounting to murder. So this is the illustration F of the section 300, and it is all exception 1 of the IPC, and this was asked in the Assam judiciary in 2018. How many circumstances has been enumerated under section 300 of the Indian Penal Code under which culpable homicide is murder? So the options are A 2, B 3, C 4, D 5. This is asked in the Uttarakhand CJ examination in 2018, where the answer is option number C, that is 4. So section 300 of IPC has 4 circumstances in which culpable homicide is murder. The next question is, culpable homicide is not murder if it is committed under A. grave and sudden provocation, B. self intoxication, C. irresistible impulse, D. all of the above. The correct answer is option number A, that is grave and sudden provocation. This is asked in the Delhi JLO and ALO examination 2016. I will give you the explanation to it, which says that exception 1 attached with the section 300 of IPC deals with the culpable homicide is not murder. Fine. So you have to see it. The next question is, grave and sudden provocation is option A, question of fact, B, question of law, C, mixed question of fact and law, D, a presumption under the law. This is important question, and this is asked in the Uttarakhand CJ examination. And so what you all think about this question? And this was also asked in the Jharkhand APO examination in 2012, and also in Bihar APO examination in 2012, and again in Tripura in 2017. So this is a favorite question among all these states, and it may come in the future examinations also. So you have to focus on this question and remember it. The answer is option number A, that is a question of fact. So this it says that it because it is under the proviso of section 300 of IPC. So if I say it is under 300 proviso, ठीक है, तो आप लोग इसको ध्यान में रखना. Proviso of section 300 says that whether the provocation was grave and sudden enough to prevent the offence from amounting to murder is a question of fact. So it comes from here. The next question is, in the context of exception of grave and sudden provocation, which of the following is correct? A, provocation should not be voluntarily provoked by the offender. B, lawful exercise of right of private defense does not give provocation. C, lawful exercise of powers by a public servant in obedience to the law does not amount to provocation. D, all of the above. So if I see these option, I think the correct answer is option number D, that is all of the above. So yes, it is actually the all of the above, because like they all are correct, and this is covered under exception 1 of section 300 of the IPC. So if you see the bare act, you will get to know the answer, and this was asked in the Haryana in 2013. The next question is, grave and sudden provocation always depends on facts and circumstances of this case. So this is the assertion, and the reason is, as per Indian Penal Code, grave and sudden provocation is a question of fact. By reading the assertion and reason, what do you get? Let me see the options. That A, what says that both A and R are true and R is the correct explanation of A. B says both A and R are true but R is not the correct explanation of A. C says that A is true and R is false. D says both A and R are false. So by reading the assertion and reason, what do you all guess? Let me tell you the right answer. Option number A, that is both A and R are true and R is the correct explanation of A. Yes, the grave and sudden provocation always depend on the fact and circumstances of the case, because as per the Indian Penal Code, grave and sudden provocation is a question of fact. So the next question, and let me tell you, this was asked in the Punjab ADA examination in 2017. The next question is, A, under the influence of grave and provocation, A, under the influence of grave provocation by Jet kills Y, Jet's child. So A is guilty of A, culpable homicide, B, murder, C, grievous hurt, D, no offence as he was under provocation. So क्या लगता है आप लोगों को इसका आंसर क्या होना चाहिए? Do comment in the comment box. Let me tell you the right answer. Option number B, that is murder. So here exception 1 of section 300 of the Indian Penal Code says that culpable homicide is not murder if the offender deprived of the power of self control by the grave and sudden provocation caused the death of a person who gave the provocation or causes the death of any other person by mistake or accident. But in the this question, there was only grave provocation, therefore A is guilty of murder. So I have given the explanation in detail, and this was asked in the Haryana in 2013. So you have to see this question, and if you have any doubt, you can pause this video and you can listen it again, and if you want to note it down, you can just stop the video and note down the questions and with the answers. So let's move to the next question. Culpable homicide is not murder if it is committed under A, exercise of right of private defense being in good faith, B, without premeditation in sudden fight in the heat of passion upon a sudden quarrel, C, grave and sudden provocation, D, all of the above. The correct answer is option number B, without premeditation in a sudden fight in the heat of passion upon a sudden quarrel. So this is attached like section of 4, exception 4 of section 300 talk about this, and this was asked in the Haryana in 2010. So this question is also important, where it says that culpable homicide is not murder if it is committed under. So you have to remember. Fine. Option number B is the right answer. Which of the following statement correctly define the term murder? So let me read out the options for you all. A, act by which the death is caused must have been done with the intention of causing such bodily injury as is likely to cause death. B, death is caused with the knowledge that he is likely to cause death by his act. C, death is caused with the intention of causing such bodily injury as the offender knows to be likely to cause death of a person to whom the injury is caused. D, death is caused under grave and sudden provocation. So the correct answer is option number C, which says that death is caused with the intention of causing such bodily injury as the offender knows to be likely to cause death of a person to whom the injury is caused. So, this is the correct statement for defining the murder, and this was asked in the Haryana examination. Next question is, A. By instigation voluntary causes death a person under 18 years of age to commit suicide. Here, on account of Jet's youth, he was incapable of giving consent to his own death. So, the options are A. Has therefore committed offence of murder, B. A. has therefore abetted murder, C. A. has therefore committed abatement of suicide, D. A. has therefore committed criminal breach of trust. Here the option is B, that is A has therefore abetted murder. This is asked in the MP examination in 2016, and this is the illustration based on exception 5 of section 300. So if I write that 300K जो exception है exception 5 which talks about this. The next question is, A appears as a witness before Jet, a magistrate. Jet says that he does not believe a word of A's deposition and that A has perjured himself. A is moved to sudden passion by these words and kills Jet. This is A, no offence, B, culpable homicide not amounting to murder, C, murder, D, none of the above. This was asked in the Tripura examination 2014, and the correct answer is option number C, that is murder. This is the illustration D of section 300. So I am covering all the illustrations of the exceptions also and the explanations also. So these illustration and the exceptions illustrations are very important to understand. That is why I am covered all these in my this MCQ. This is although a long one, but yes, it has covered this topic wholly, and my part 2 will also come, but it will take a little time. Till then you all just revise the part 1 of this video. So the next question is, X appears before A magistrate and said that he was not believing a word of this I have repeated. An exorcist beaten to death a girl for exorcising her of evil spirit. He is guilty of A, murder, B, culpable homicide not amounting to murder, C, causing grievous hurt, D, attempt to murder. So the next question, the right answer is option number A, that is murder. So yes, it is again in the section 3 illustration. You have to see that it is under illustration D, and also in the explanation it is been given of the murder, which is has this question has been asked in the Punjab ADA examination in 2017. Yes, the next question is, A has put a loaded pistol on the temple of B and asks him to walk backward without seeing behind him. When B walked backward and fell down from a steep fall of the hill and died. A has committed the offence of A, murder, B, attempt to murder, C, culpable homicide, D, grievous hurt. This is a straightforward question, and yes, the answer is option number A, that is murder. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. Although he may not have had a premeditated design to kill any particular individual, A committed the offence of A, section 299 of IPC, B, section 300 of IPC, C, section 304 of IPC, D, section 304A of IPC. This is a favorite questions among various state examinations, and the correct answer is option number B, that is section 300, and 300 says that it is a murder. So it is has been asked in the Rajasthan APO, MP judiciary, UP judiciary, Chhattisgarh, and also in Himachal Pradesh. So these has been this question has been repeatedly asked, and this is the this has been one of the favorite questions among all these states. So the next question is: A shoots B with the intention of killing him. B dies in consequence. A is guilty of. This is also again direct question. A murder. B culpable homicide. C both A and B. D none of the above. These questions are in the revising form of questions. So if you say कि बार बार इसका ऑप्शन हाँ देखो मर्डर ही आ रहा है, ये भी मर्डर, बट जब आप एग्ज़ाम में बैठोगे तब आपको ये डायरेक्ट क्वेश्चन आएगा, ज़रूरी नहीं सीक्वेंस वाइज में आएगा, कोई भी क्वेश्चन उठा के डाल सकते हैं. तो यू मस्ट सी कि कौन सा क्वेश्चन के ऑप्शंस क्या क्या हैं, क्योंकि आप अभी तो सीरीज़ में पढ़ रहे हो बट एग्जामिनेशन में सीरीज़ फॉर्म में नहीं आएगा. सो द करेक्ट आंसर इज ऑप्शन नंबर ए, दैट इज मर्डर. The next question is: A fires on a crowd for no reason, as a result of which B dies. What offence A has committed? A culpable homicide not amounting to murder. B grievous hurt. C murder. D none of the above. So the correct answer is option number C, that is murder. तो आप लोग प्लीज़ इसको एज अ एग्ज़ाम्पल या एज अ इलस्ट्रेशन ऑफ मर्डर के तौर पे इसको याद रखिएगा. X drives very fast through a crowded road to catch a flight, knowing that his act in all probability may cause death. Y is killed by his vehicle. X is guilty of: A culpable homicide not amounting to murder. B murder. C grievous hurt. D negligence. So the correct answer is option number B, that is murder. And this was asked in the MP judiciary and Chhattisgarh judiciary. In which of the following landmark cases a 3-judge bench of Supreme Court prescribed 4-point test relating to section 300 thirdly of IPC? The options are: A Virsa Singh versus State of Punjab. B State of UP versus Ramesh Prasad Mishra. C KM Nanavati versus State of Maharashtra. D Nehru Jawahar versus State. So this correct answer is option number A, that is Virsa Singh versus State of Punjab in 1958. Let me tell you, I will not tell all those 4 points, but yes, in the Virsa Singh versus State of Punjab, the court observed that the prosecution must prove all those 4 points which can bring a case under section 300 of the IPC. And I will tell you, this was decided with the Justice Vivian Bose. Justice Vivian Bose, who was the judge in this landmark case, and this was our APO CBI examination in 2017, under which one of the following case: first time Supreme Court of India has reaffirmed the distinction between the culpable homicide and murder, willing adopting to view suggested in Govinda case. The options are: A Inder Singh versus State of Pepsu. B State of AP versus R.R. Punnaya. C KM Nanavati versus State of Maharashtra. D Madhavan versus State of Kerala. So the option hopefully आप लोगों को पता होगा ये, but if not, let me tell you the correct answer. Option number B is the right answer, that State of AP versus R.R. Punnaya. In this case, the Supreme Court held that in the scheme of the Indian Penal Code, culpable homicide is genus and murder is its species. All the murder is culpable homicide, but not vice versa. So speaking generally, culpable homicide has the special characteristics of murder, and culpable homicide not amounting to murder. So I've already told you this in short the what Supreme Court held in this case. So the next question is, punishment for murder is A. Death, B. Imprisonment for life, C. Both A and B, D. Death or imprisonment for life and fine. The correct answer is option number D, that is death or imprisonment for life and fine. So this was asked in the Bihar APO in 2012. Section 302 of IPC states about its punishment. The next question is, A. Being a medical expert blows on the head of B, who is suffering from third stage brain cancer. Consequently, B dies immediately on the spot. A knows the fact that a blow on the head of B can lead to death. What offence A has committed? Option A. Murder, as A knew that his act is likely to cause death of B, to whom injury is inflicted. B. No offence, as the blow would not have caused death of a normal man in ordinary circumstances. C. An offence other than murder or culpable homicide not amounting to murder. D. Culpable homicide not amounting to murder, as A knew that his act is likely to cause death. So the correct answer is option number A, murder, as A knew that his act is likely to cause death of B, to whom injury is inflicted. So this was asked in the MP Higher Judiciary in 2017, and this is again under section 302. He will be convicted under 302 of the IPC. It embodies what the English authors describe as the doctrine of transferred malice. So doctrine of transferred malice is under section what? Option number A is section 301, B is section 34, C section 149, D section 304A. The correct answer is option number A, that is 301. So transfer of malice is under 301 of IPC. Like if I say in my explanation, yes, culpable homicide, it deals with the culpable homicide by causing death of a person other than person whose death was intended. So here the malice has been transferred. The next question is, A intentionally fired a shot from his pistol at B, but it hit C and C died. The offence committed by A is A. Attempt to murder, C. Culpable homicide, C. Murder under section 300 of IPC, D. Murder under section 301 of IPC. So the correct answer is option number D, that is murder under section 301 of IPC. This is again the transfer of malice. A with the intention to kill shoots aiming at B, instead C gets killed. The principle holding A is liable is known as A. Doctrine of intention, B. Doctrine of transferred malice, C. Doctrine that no one can escape, D. None of these. The correct answer is option number B, that is doctrine of transferred malice. X intended to kill A but instead killed B, whom he had no intention to kill. Under which doctrine is X liable for murder of B? Yes, this is the extended version of my previous question, but question may be asked in this way also, because this has been asked in the Haryana and MP judiciary repeatedly. So that is why I put this question, and the options are doctrine of extended malice, B. Doctrine of mens rea, C. Doctrine of diminished responsibility, D. Doctrine of transfer of malice. So people get confused in the option number A and D, but the correct answer is option number D, that is transfer of malice. A intended to cause death of B, caused death of whose death he neither intended nor knew himself to be likely to be caused, and it happened. In the description of his intention to cause B, death of B, A, option number A is guilty of culpable homicide not amounting to murder. B is guilty of murder. C is entitled to plead defense of accident. D can be given benefit of doubt. So what do you understand with this question? Okay, fine, let me give you the answer. The option is A, that is guilty of culpable homicide not amounting to murder. So here you see if like the option can come like this, and culpable homicide by causing death of a person other than a person, and this is I have told it will be the transfer of malice, but here it is of culpable homicide not amounting to murder. So you have to note down this question and you have to just focus what this is asking. X on receiving grave and sudden provocation from Z intentionally caused death of Y, who is brother of Z. X has committed the offence of A. Murder, B. Culpable of homicide not amounting to murder, C. Grievous hurt, D. Attempt to murder. The correct answer is option number A, murder. People will get confused between the option number A and B, but if you see, this will come under murder only, and that is why like I have told you, already this question has been based on the section 301 of IPC, and that is why it will be covered under murder. And this is my last question of this video, and I hope आप लोगों को ये series पसंद आई होगी. If there is any doubt, do comment in the comment section and let me know if like there is any doubt and confusion. And आप लोग प्लीज़ इस वीडियो को फिर से सुनिएगा, रिवाइज करेगा, बिकॉज माई पार्ट 2 will also come, rest of the question will come in part 2, क्योंकि ये वीडियो थोड़ा लंबा हो गया था इसलिए मैंने इसको 2 पार्ट में डिवाइड करने के लिए सोचा है. So this is the part 1, part 2 will come soon, and till then take care, do revise and do share this video. If you like it, please hit the like button and comment if you have any doubt.